Hi, I'm Julian Nacol on behalf of Nacol Law Firm. We're going to be talking about wills versus intestacy today. Now, what I always tell my clients is if you want to make life easy on your family, you get a will done. A will, you're going to be looking at $25,000 to $3,000 to probate it. Intestacy, if you die without a will, your family or the estate is going to have to pay anywhere from $7,500 to $10,000. Here's the difference. With a will, they call it an independent administration. You appoint your executor. That's a person that goes up, the judge validates what the will says, appoints him power of the estate. He can clear up title, make payments, distribute assets according to the will. If you don't have that, you go intestacy. Now, intestacy is a codified statute that says what each children get in case there is no will. Furthermore, it's what we call a dependent administration. So a dependent administration involves a lawyer going up each time to make certain allotments, changing titles. They have to continuously come back to the court to get permission. Furthermore, what we call an ad litem, which is an attorney appointed by the court to interview potential heirs in the estate, will be appointed in the intestacy, and they're going to suck up money as well. So if you want to waste a lot of money on attorneys, then don't do a will. That is my advice. Now, if you have a will, you can determine wherever your assets want to go. If you want all your assets to go to your great niece, and you can do that. Or if you want to do a trust for your pet, a pet trust, and leave $4 million to little Minnie, that's fine. You can do that for a will. Now, if you don't have a will, we follow what Texas says, Texas law. Now, the example I'm going to use is a typical family, mother, father, 2 kids. Both kids from the mother and father, never divorced. The father dies. The mother will receive all his community property, his half of the community property. She will receive 1/3 of the real estate with a life estate onto it, and a homestead exemption may apply. The other 2/3 of the real estate will go to the children in equal divisions, and the remainder of the life estate will go to the children when the wife dies. Now, that is just an overview. There are many permutations and many different types of distributments depending on the family. If there are kids you're not even aware of, if there's common law marriage, if people were common law married after the will, that could be a big change. The important thing is to save your family a lot of grief and not to incur a lot of attorney's fees. Get a will done. With a will, you can do testamentary trust as well. And a testamentary trust is a trust you place for your children, which will allow whoever you determine to be a trustee to isolate the money so creditors can't get to it, if it's a spendthrift trust, and ensure that your children are protected if you have an unfortunate demise. So if you have questions on contesting a will or probate, there are many ways a will can be contested as well. Undue fraud, duress, coercion, if alleging that the person doing the will lacked his mental capacity at the time. They are hard to prove but possible. Give us a call, 972-690-3333, or check out our blogs on NacolLawFirm.com. Thank you.